and Physics at university. I'm now the Deputy Vice Chancellor at University of Zululand, where my role is in institutional support. And I'm also interested in living the life of the mind, but also more concerned about the state of our democracy.
We live in trying times indeed. Never in the history of SA, well, as far as I can recall, where the judiciary seems to be towing a particular political line. What is your assessment of the current state of our judiciary?
Well, first, there are three issues that I want to raise. That the judiciary, the role is to ensure that the justice is served. And secondly, is that the concept of justice is not a notion that the judiciary holds monopoly on. And this is why we always talk about the justice must be seen to be done. So all people have an innate sense of what is fair, what is reasonable, and what is just. What the courts are there to do is to assist in the resolution of conflicts. But in doing so, they must be seen to be delivering on justice. But we must also understand that the courts are made by people like you and me. And we as people are imperfect human beings. And the judicial system understands that and acknowledges that the judges may not always be correct. This is why you would have a case that would be decided at the magistrate court, and it can be taken to a high court where it is appealed, or where somebody calls for its a reviewal. And even when the high court has made the judgment, you can still review the decisions of the judge decision at the high court to the Supreme Court of Appeal. And you may also, if you are unhappy, take the matter from the Supreme Court of Appeal to the Constitutional Court. So when you see this, you see a hierarchy that has been created precisely because we acknowledge that judges are human beings and they are more or likely to err like all of us. So when we approach the judiciary, we must approach them with that degree of circumspection and also degree of suspicion. It is not just because somebody is wearing a judicial garb to assume that those people will deliver justice. This is why even the high court decisions get overturned at the Supreme Court of Appeal. And even when the judges of the Supreme Court of Appeal have made the decisions can be appealed at the Constitutional Court. And as a matter of fact, the high court decisions have been overturned. As a matter of course, and in fact, the Supreme Court of Appeals decisions have been also overturned at the Constitutional Court level. But also, some people have taken the Constitutional Court to court. The Judge Klope did that, and the Judge Mujapelu came up with a conclusion that the very highest court in the land had violated the rights of another court. So we must understand that ultimately, the people can make a discernment on whether the court has acted in a manner that advances justice, where the court advances what is considered to be fair. And in the last year or so, we have seen judges, including the Constitutional Court, where I think they have thrown what I call the rule book. And when that happens, we have a duty as a people, and actually as patriots, we have an obligation to point that out. When the court begins to act in a manner that undermines justice, we have a right to say, you are actually failing. So I want to pack that. Then there's a second issue I want to raise. It is the issue of the supremacy of the Constitution. Most people tend to confuse the supremacy of the Constitution with the Constitutional Court. We can talk about the supremacy of the Constitution as simply saying, when the Constitution says this, but we expect that the concord made of individuals must interpret that properly. They must not be expedient in doing so. So there have been instances where the courts have actually shown that they don't seem to be serving the interest of justice, but they seem to be serving the interest of politicians. Our courts have ruled a number of times that transparency and open democracy is critical, that we cannot be in a democracy where information that is critical in this country gets sealed. But the very same court, when it comes to Cyril Ramaphosa, they always come and tell us that information that relates to him should be sealed, that we don't have the right to know. Even organizations like the Right to Know have also joined forces, because when it involves other people, they'll be the first to rush to the courts to say we have a right to know. But when it comes to Cyril Ramaphosa, we don't have the right to know. Organizations like the Helen Suzman Foundations, the Amat Katradas, all these foundations, they'll be rushing to the courts to say we need to know information. But when it comes to Cyril Ramaphosa, they and the courts collude and tell South Africans that you are too intellectually inadequate to be able to be given this information. There have been two instances. There was before Ramaphosa became a president, there were these emails that had been found. Ramaphosa rushed to courts to say the people should not know about this information. And yet the very same Ramaphosa was busy pontificating in stadiums, saying we need to know the emails about the Guptas. But when it comes to him, his emails must not be known. Now we have a campaign finding, the CR17, where it is alleged that the certain judges may have received some benefits or may have been bought. This is said so many times, and that information and the names of the judges are known. But the court had said this must be sealed. So the question that ordinary people must ask, what is the court afraid of? And what is Ramaphosa afraid of? If Mr. Ramaphosa is a broom that will clean sweep, if he's incorruptible, the simple question is, what do you have to hide? So those are issues that the very same courts that tell us that it is very important that we know, that we have a right to know, especially when those who are in power that make certain decisions, we need to know their affairs. Because once you become a public figure, you are exposing yourself. So here we have always said that when you talk about the democracy, you're talking about the government of the people by the people. But we also know that it is not only private citizens who have an interest in what happens in government. Businesses also have that interest, but businesses do not vote. So we are saying transparency is important, so that when policies are made, decisions are made, we should be saying these decisions represent the voters. They do not represent business interest. But the courts have told us that we don't have right to know. So that tells you that we don't have the judiciary that is consistent in the application of the foundational value of a democracy, which is the transparency. So that is one instance. We had also another instance. Actually, we've seen Zondo Commission. You've seen that when Brian Molefe appeared before the Zondo Commission, Zondo spent more time worried about what Brian was going to say. But when all other people were saying things, maligning others, he had little concern, especially when it involved Jacob Zuma. Instead, he would egg on the people who were making that representation. So you know that here you have a judge who has actually shown a degree of bias. And when Brian came, he was more concerned about Brian making sure that he does not accuse the president. But Brian was simply saying, Mr. Chairperson, I'm simply giving you the facts. Your people must go and investigate as they are eager to investigate other people. So you have Zondo himself, who has not dressed himself in glory. So that actually shows that just because you are a judge does not mean that you can always deliver justice. And the people can see through that. And in this case of Jacob Zuma, you have a judge who has a relationship with Jacob Zuma. And people had raised the issue that, and Jacob Zuma has raised the issue that I want to appear before the commission, but you need to recuse yourself because of the relationship that he does not dispute. The only thing that he disputes is that he's not the friend of Jacob Zuma. But you would have known that as soon as there's a suggestion, especially when you as a chair, you start arguing with somebody who appears before you about matters of fact, that means you have now moved from being a neutral person, you have become a participant. So this is a simple, obvious thing that as Zondo, you cannot be both a player and a referee. But something as simple as that escapes Judge Zondo. And this is what Jacob Zuma was raising. Then you have the Constitutional Court's ruling on Jacob Zuma. Zondo, who has a case before him of recusal, rushes there and says, I want you to force this person to appear before me. And he does not tell them that, but this person has an intention and may also have already filed for my recusal. You would have expected that the court that is aware of that, the Constitutional Court, would have said, but surely there's this other issue. Instead, the court decides not to comment on that. But we know that in terms of the rule book, if there's a case that is pending in the lower courts, the higher courts wait for the lower court to make and to come up with a judgment or a decision before the matter comes before them. But the Constitutional Court chose to pretend that they don't know that. So here you see again an element of dishonesty. Then you also have an issue where the highest court in the land says Jacob Zuma can appear and that he has a right to remain silent only to those issues that may implicate him. And our Constitutional Court is very clear that in affairs that involve you, you have a right to fair hearing, you have a right to remain silent. Even when the police arrest you, they say you have a right to remain silent, for everything that you say may be used against you. So the Concord, Jacob Zuma cannot know ahead of time which charges would be preferred against him. So for you to force him and to say you don't have a right to remain silent is very problematic, because it goes against the very grain, very stipulation that are in the Constitution. So you ask, which Constitution are these judges reading? So you can see we have instances where the judiciary has become suspect. And when the judiciary oversteps, when you have the judiciary becoming active in the factional politics of the ANC, we have a right to raise those issues sharply. And also, as I say, it is the obligation of every patriot, every citizen, that when you think the court are not doing their business properly, you must resist, you must raise those issues as hard as you can.
Definitely a fitting answer to that question. But the question oftentimes comes, if South Africa is said to have the best constitution in the world, from what we know now, its application is conditioned or conditional. One wonders when it was formed, how it was formed, by whom, and to what end even.
Yeah, well, I mean, we must also be honest around our constitution. We, as it happens to be the tendency of African people, we have suspended our own intellect. We have suspended our brains from working. Most of the stipulations that are in that constitution, when you read them carefully, you can see that they were there to sustain the status quo. This is why 25, 26 years later, the conditions that existed in 1994 in economic relations remain the same. This constitution that is said to be the best in the world, it is said to be the best in the world by those people who know they are going to benefit, where it's a constitution that has protected the privileges and advantages that people got. Let me give you a simple example. Before 1994, most of our people were living in squatter camps. And when the constitution was written, they lived in the squatter camps. Today, we have more squatter camps. Today, we have Black people, the inequalities have multiplied because the constitution protects that. So our constitution, in simple terms, forced us to reconcile ourselves with our poverty and encourage white people to reconcile themselves with the wealth that they got as a result of both colonialism as well as apartheid. But the constitution simply gave people, Black people, hope that if you are going to address these inequalities, this will be addressed through what they call progressive realization based on availability of resources. They knew fully well that we were inheriting a bankrupt state. They knew fully well that by ensuring that these are stipulated, these socio-economic issues, that they'll be progressively realized, that it will take forever. And as we speak, we are nowhere near getting the land back. And people have said, for us to be able to turn things around, to reach a possibility of equality, it will take 200 years because of this constitution. So, but we are also lazy because the constitution people don't exist for the constitution. The constitution can be changed, and the constitution can be, or put differently, it anticipates that it will be changed. But because some of our people have been captured, that some people, like in conditions of slavery, you'll find what you call the house slaves and the field slaves. We have what they call the house Negroes, who have been co-opted, and most of them are from the ruling party. Look at some of the leading giants of the ruling party. They serve on boards of companies that belong to other people, and they are not invited into those boards to advance any revolution. They are co-opted to frustrate a revolution. So we have a problem in this country that some of our own have become enemies of changes that will advance the conditions of Black people. So, and some of them have become instant millionaires because they are rewarded for doing a good job, which is to keep Black people where they are, to keep Black people in conditions of squalor, in conditions of desperation. Even as we speak today, our people are the ones who are affected and affected by this pandemic, precisely because we have a dispensation that is anti-Black people, anti-African, and anti-poor.
Most definitely. Let's talk a bit, about the Zondo Commission. Close to 1 billion if it hasn't exceeded the amount already, and yet it doesn't have enough powers to prosecute. They can merely suggest. But now, if the president is also implicated through the evidence of Brian Molife, to whom must the report be handed to, and what are we likely to see taking place as a result of that?
Well, the very same courts, when it came to Jacob Zuma, talked about him being too implicated and maligned in certain reports, and therefore he should be recused from being active in matters that fall within the position of the presidency. We still have not heard the loudmouths who claim to be constitutionalists saying, because you are conflicted, this report must not go to you. But what it also shows that the so-called constitutionalists are simply hypocrites who are there to protect white privilege and white interest and to keep black people subjugated forever. So the question that you raise is a critical one. And as I say, the courts had ruled that if you are conflicted, you have no business in the adjudication, in even receiving that report. But like all hypocrites that we have in this country, they will never say anything. So what we have here, we have a prepaid democracy, prepaid by those who have the monies, and those are actually showing that the ANC was always ready for capture, and now it is totally captured.
I want to talk briefly about the public protector, Busisiwe Mkhwebane, Advocate Busisiwe Mkhwebane. We saw in the week when the DA and the ANC were willing to be in collusion to make sure that her tenure is unceremoniously ended. But the question is, if the public protector had not touched the CIX report from ABSA, if the public protector wasn't doing her job, meaning putting things into perspective and making sure that facts and the public is actually protected, would we be seeing what is currently happening? Please also draw comparisons between the tenure of Thuli Madonsela and what we've now discovered as a job not so well done, and what has become now of Advocate Mkhwebane and the job that she has done and how things are being managed, through the media with regards to her reputation.
Yeah, first, one of the things that we have always made a song and dance about is issues of clean audits. What it means is that when you run a department or you run your business and you run an entity, clean audits are an indicator that you can account for the sense. For the first time since the Office of the Public Protector was established, it has achieved a clean audit. What it means that he can account for every cent, which previous public protectors could not do. So that's the point number one. She has already resolved about 60,000 cases. And she has had 4 cases that involve the one that you've also said, that are being challenged. So if you look at 60,000 cases that have been resolved, and you look at the 4 cases that remain unresolved, and you compare that with the previous public protector, you would actually think that the previous one has done a good job, when in fact she has not done so. But she has been used as an instrument to target the ANC, and in some cases, rightfully so. I mean, we should not defend the ANC when they do wrong. But the problem is when you touch the high and mighty, then you are actually reminded that the white rules. And what is also interesting is that the DA put a motion, and a motion that was also informed by a panel that was looking at the Busisiwe Advocate Mkhwebane as a tenure and decision that she had made on 4 cases. It is according to Advocate Ngalwana. But in those cases, 3 of them are being appealed. And we know that when a matter is before the court and pending before the courts, the parliament has no business going in there. But in this case, parliament also broke its own rules. I'm told it's Rule 89 of parliamentary rules, that matters that are pending before the courts, it will not deal with them. But the rules become irrelevant when white power has decided who to crucify. So Advocate Mkhwebane is actually being crucified, but she's being crucified even by her own people, who should have actually said, what do the rules of parliament say? So that's the first one. The second one is that even the case where she was found to be incompetent, the one that involves CX, the Constitutional Court itself was divided. If my memory serves me well, the Chief Justice did not agree with his colleagues, effectively saying, I'm reading this information that you guys are choosing to ignore. So you can't, when even judges are divided and say this person is incompetent. But what is also interesting is a case that is pending before court where she was told that she was relying on a wrong provision, on a wrong code, that she was applying a code of 2007. And yet the very same people know that they were referring to code of 2000. And the public protector is actually correct to refer to a later code, because what it does, it removes or updates the old code. But you have judges who have chosen to pretend that the code of ethics of 2007, which support the public protector, which she actually used, exist. So this is where the media begins to play a very dangerous role. What it does, it begins to create or to manufacture a particular consensus. Now, the last point I want to raise about the caucus. What happens in caucus is that the caucus of parties, when there's an issue to vote on, it gets debated. And then on the basis of perspectives, then members of parliament will come to say, either decide on the conscience or use a majority to say, as a party, having considered and having debated this matter, this is where we stand. What we saw this week was simply an instruction on how they should vote. Effectively, nobody in this country should take members of the ANC seriously, because we now know that they are simply reduced to a voting kettle. They were told that they suspend your intellect, suspend the working functions of your brains, and vote in this particular way. And of course, others, out of fear of reprisals and punishment that will go against their own conscience, chose to come up with excuses that there was a problem with connections, but all they were saying is that we could not, in all consciousness and political consciousness, vote for this motion, especially when it has not been debated. We know for a fact that members of the ANC held different views, but Gwede Mantashe went there like a dictator and told them how to vote. And like voting cattle, they voted as they were told. So that, if you think you have members of parliament who are guided by their own conscience, you have to rethink that you need to recalibrate. Know that what you have is not deliberations, is the interest of certain people who themselves may somewhere be implicated. You would have thought that one of the things that you try to do is to say, were these people conflicted, how many of them have been found wanting by the public protector, like the speaker? So you see a whole range of dishonesty in how this matter was dealt with. But what we know is some members chose not to vote precisely because they could not, in all honesty, follow the dictates of the DA. But as we know, and as the DA leader himself had put it very clear, that in the ANC, they've got MA money in Ramaphosa. That's why they say that we will work with Ramaphosa, will not work with all the rest, because we got rid of our money. We are now concentrating on the money of the ANC, which is Cyril Ramaphosa.
Scary times we live in, indeed. I want to quickly zoom into the sense that we're getting, or sentiment, that whenever there's factionalism within the ANC, state institutions can be used to chase perceived enemies. What do you make of the NPA, the Hawks, particularly the North Gauteng court, which stands ready to always defend and attack people that seem to be against a particular cabal?
Well, I mean, take a simple case of Duduzane. When Duduzane was out of the country, the media made a song and dance about how corrupt he was. All sorts of allegations. And the poor fellow comes home to bury his own brother. He is immediately arrested, shackled, driven to the court. And you know what is interesting about shackling of black people? It's the same way as they did with him, Mqebo Dlamini, put on chains. And then you find white people who had killed people appearing on murder charges without chains. That is South Africa's justice. That reminds that the black men, you are on your own. So Duduzane was shackled to the court, but they did not have a case. So if you want to talk about law enforcement instruments being used for political gain and for to settle political scores, that is one simple case. And when the NPA found out that it had no case on Duduzane, they had to resurrect another case, and a non-case about an accident. They also lost. So what you saw there is the desperation that one Zuma must go to jail. And it is something that the mainstream media had been championing. And we find our law enforcement agencies doing exactly the same. The same applies to Bongo. It was very clear that the state did not have a case when they took him on issue of either fraud or corruption. They had one witness, and that witness could not even sustain the stories that he had told other people, and the case was thrown out. You would have thought that when you charge somebody, you charge that person on the basis of existence of irrefutable evidence. You don't take chances because you do not like people. So it is a matter of public record that our institutions are very biased in how they handle issues. So I do think that, again, when that happens, in the same way that people rebelled against the injustice of apartheid, they should rebel against the injustices that are perpetrated in the so-called new dispensation, which is the old dispensation. Black people are still in that condition where they've got a knee on their neck. They can't breathe in the new dispensation.
Whilst we're still on the NPA, Steinhoff under Marcus Jooste embezzles over 250 billion rands, vanishes out of the blue. Nobody knows how it happened or why it happened. Marcus Jooste is still a free man. The same Steinhoff takes out a couple of millions, donates it to the NPA to investigate itself. What do you make of this circus?
Well, it's an insult to the concept of justice. It's also an insult to black people. It simply says, if you are black, if you're black, you'll never get justice. If you're white, you'll always walk away. Now you have, like you say, we're talking about over 200 billion. That was part of the public investment.
Yes.
And yet, read the media, how it made song and dance about the Nkandla, which did not even cost $1 billion. Now we have spent even almost close $1 billion on Zondo Commission, where what we know has been largely hearsay and more hearsay. And the more people are interrogated, the more you see how Zondo has shown his bias, that there's certain information that must be suppressed. So we are in trouble. What it means is that South Africa is up for sale. Our judicial system is up for sale. Our law enforcement agencies are up for sale, and they can easily be bought. In the same way that our leaders who sit on major boards of companies they did not create have been bought. And this is why every time they speak about white interest and white privilege, and they are bought to protect that. They have become the enemies of the people.
Prof, another issue that we saw recently also was Judge Hlophe being taken in and out of court over something which some may claim is a non-starter. But there is an insistence on targeting certain individuals who may or may not be perceived to be aligned with President Zuma. Advocate Simelane emerged from poisoning. Now we see some of them being taken in and out of court. We made an example, for example, of Advocate Bongo. We know Mkhwebane, we know the cases around her. What do you make of this seeming trend of targeting judges who may or may not be aligned to President Jacob Zuma?
Yeah, I mean, when even before Judge Mujapelo came up with a judgment on the behavior of the Constitutional Court, where he found that they had actually violated his rights, I had written an article which will come out in my next book, where I said the Constitutional Court is behaving no different than kangaroo courts in our townships, where you had judges collectively saying they are going to have somebody charged on the basis of hearsay, because they had other judges saying this, but those judges said we are not even sure that was the case. But they so excitable are our judges. But what do you find in there? In the same way that I must suggest that I think Zondo's behavior must be seen in the context of his personal ambition. He's too desperate to become the next Chief Justice. And he knows that to be the next Chief Justice requires a political act. It's a political decision. And if he acts in a manner that supports or promotes the interest of a person who might make that judgment, then so be it. So I think the Constitutional Court in that matter erred, but there was somebody like Dikhamu Seneke, who I think was desperate to become the next Chief Justice. And the people like Hlophe were stumbling block. In the same way that you remember how Dikhamu Seneke behaved during the hearing of Mogoeng. He should have recused himself as somebody who had an interest. But what we know is that even those people who know that that was improper for him to chair that, given his interest. But if you are liked by the white media, you are liked by white monopoly, you are liked by those who advance white interest, all these things disappear. Your interest in whiteness simply takes away any form of blame that may be thrown at you.
It's quite scary times indeed that we live under. I want to zoom into Mogoeng. The media is the first to always over-exaggerate his statements. They're the first to throw him out in the court of public opinion and allow, or not rather allow, but impose a particular notion or perspective on the public. Do you feel that his personal utterances as a Chief Justice should be always misinterpreted as an authority or authoritative statements under his capacity as a Chief Justice?
Well, my sense is very simple. As I said, judges and we must affirm their humanity. And those who judge others, we must also be looking at them, because there are those who try to present themselves as holier than thou. And it may be that we expect him to have restrained himself in certain comments. But it cannot be that after that we start presenting him in the negative light as we have always done. Mogoeng was presented as a skunk of the judiciary until he came up with a judgment on Nkandla. He became an instant celebrity after many of his colleagues were trying to remove him, to impeach him, to do all sorts of things. So what is happening to him right now is something that started when he raised his hand to say he's available for being a Chief Justice of this country. And most importantly, a lot of nonsense, which I had also commented on, was raised. And yet Mogoeng is the only Chief Justice this country has produced who had been on the bench longer than his other previous chief justices. For instance, somebody like Chakerson was put in that position without even having been a judge. And some people say even having been an acting judge. But when you are white, these things are not raised. But they will also be raised by black people. That is how messed up black people are. That all they need to do is to get marching orders from their handlers who happen to be white, unfortunately.
Concluding question, has the SA Judiciary become a law unto itself?
Well, my answer is definitely yes. Until they are, first of all, they must continuously prove themselves. And I think at the moment, the answer is that for me, some of them have shown that they are a disgrace. I mean, there was a judgment in the High Court where the court, out of the blue, 3 judges start telling us about how great the new dawn is. And this is an inner judgment. And they talk about the new dawn that is performing miracles. The miracles that is more in their heads than in reality. So when you have 3 judges having no problem in penning a judgment starting with a political statement, then you know that this judiciary has become a law unto itself, and it has thrown the rule book out. And we must worry. And when that happens, as I said, we are obligated as citizens, as patriots, to rebel against the abuse of power. And in this case, judicial power.
Definitely. Prof, always is a pleasure talking with you. I guess all of our listeners now definitely understand why we termed our conversation, has the SA Judiciary become a law unto itself? Nobody can dispute the fact. It's in the media, it's known, we see it playing every day on TV. The SA Judiciary has to some degree become a law unto itself. Thank you so much for your insights, Prof. Always is a pleasure.
You're welcome.
Thank you. Do take care and enjoy the rest of your day.
Take care.